Before you file your appeal with the federal court or file your reapplication with the Immigration of Canada, you must first understand the whole process before you spend the time, money, and effort with your legal representative. So today we are going to have this crash course on what the whole process is all about. Hello, I'm Attorney Rene Bueno. I am the Chief Executive Officer of Counselors for Immigration and International Studies. For the last 16 years, we are helping people move to USA, Canada, and Australia. And in fact, we have already deployed more than 10,000 young people to these three countries, either by migrating directly to these countries, participating in the cultural exchange program, or studying and working at the same time in USA, Canada, and Australia. Please keep in mind that this is not a legal advice but a mere general information based on my more than 16 years of experience working with a prestigious Canadian law firm and a U.S. immigration law firm in Washington, D.C. Whether it is for yourself, for your business, for your spouse, or for your children, or for all of the above, we do make it happen. So let us start now so you can study, work, and live permanently in these three countries now. Okay, the first step is for a judicial review. If you receive an adverse decision regarding your application for a study visa, working visa, immigrant visa, or an investor visa, the first step is for you to file a request for the written reasons for your visa refusal. And upon receiving the visa refusal letter, then you should discuss this matter to your immigration lawyer and determine whether or not there is a good chance of reversing the decision of the immigration court. Or you may just discontinue with the litigation because it is a very long legal process. Aside from the fact that this is a very expensive one, you need to convince the immigration court or the federal court that there was really an error of law in your visa decision. If the court decides not to hear the case, then the matter ends there, and the court is not under obligation to give any reasons or explanation regarding the matter of not granting the leave, and the case is dismissed. If your case is already within the jurisdiction of the federal court, the court may grant leave and decides to hear the case, and the case may be resolved within the period of 3 to 4 months' time. This is the law in Canada, and the courts are not bound to give any reasons on why your case is being dismissed. Briefly, that is the judicial review. So it is a very long litigation process, it is very expensive, and we usually do not recommend that the clients file a petition for a judicial review. There is another way of reversing an adverse decision rendered by the Immigration Department, and this is the administrative review, which is a shorter period of time to get the decision, and at the same time, the person is allowed to submit additional requirements or proofs in order to reverse the decision and to convince the Immigration Department to reverse their previous decision of the visa denial. And at the same time, in the administrative review of your visa refusal, it is going to be a different immigration officer that will handle this reapplication or review or the administrative review of your visa refusal. Immigration lawyers actually do not encourage the applicants for a study permit to file a judicial review of their visa refusal. What they usually tell the applicants, particularly for a study permit, is to reapply the application for a study permit. There is actually a better chance of reapplication because the student may be allowed to submit additional documents or proofs that would convince the immigration officer that the applicant has very strong social and economic ties in the country where he belongs or the country of origin. There is always a risk in everything. There is never a guarantee that your application for a study permit will be acted favorably by the immigration department. Everything has a risk. There you have it. The entire process is summarized for you in a very simple terms so you can understand the whole process and the steps that are needed in order for you to start your reapplication or take the option of a judicial review with the immigration department. If you need guidance on your visa application, particularly for a study permit, then do not hesitate to contact us and we are very much willing to help you in your visa application. Also, please click and subscribe to my YouTube channel, and if you will do that, you will be entitled to a free one-on-one legal consultation with Attorney Bueno. Magandang araw po sa inyong lahat at sana'y nagustuhan nyo at abangan ninyo ang aking mga susunod na video dito sa aking YouTube channel.